Hello and welcome to another edition of Inside Family Court. My name is Bill Tingley. Our guests today are Judge Kevin Garvey. Judge Garvey's been on the bench since 1981 and joined the family court in June of 1999. Our other guest is David Gittleman. Mr. Gittleman is an attorney in the Louisville community. He is also president of the Kentucky Mediation and Arbitration Service. Mr. Gittleman is also the chairman of the KBA's section on alternative dispute resolution. Gentlemen, thank you for being here with me today. And as you both know, our topic is mediation. And my first thought, looking at you, Judge, is that in 1981, I doubt they were doing very much discussing of mediation.
There wasn't much discussion on mediation. In fact, it was a concept that really never came up very often.
David, give us, if you will, as we start out this discussion today, a good working definition of mediation.
Mediation is a process where an impartial third person, a mediator, assists parties who disagree or can't agree in making decisions, in reaching agreements that are satisfactory to them. And I don't want to leave out that the mediator has no decision-making authority. The parties have complete control of the decision-making. The mediator is a catalyst to discussion, to some degree a traffic person to keep everyone at the table talking and putting their effort towards getting the facts out and reaching agreement.
Judge, how does this compare and contrast to what happens inside the courtroom?
Well, in the courtroom, there is no negotiating. Parties present their side of the case. Usually, our system is an adversarial system, so I compare it to going to battle. And once all the evidence is in, the judge goes into his or her chambers and makes all the decisions. Mediation is an opportunity for the parties to have some control over the outcomes rather than having the outcomes forced upon them.
David, are you able to do things perhaps in mediation that the court maybe can't do?
Well, a lot of things in a lot of different ways. It's the parties usually talking either to the mediator or talking directly to each other, expressing what they want, trying to understand where each one is, and then often it's not uncommon for them to reach agreements relating to children, relating to their property, that a court sometimes doesn't even have the legal authority to do for them.
Judge, pick up on that. Can you give us some, for instances, or extrapolate on
There are
that?
some good examples of where in mediation the parties have an opportunity to create some options that aren't available to the court. One area is in education of their children. All along during their marriage, the parties may have planned to send their children to a certain school, and they can agree to that in mediation, and it's something that the court could not order done. They could also talk about college for their children, which again is something that the court could not order. So there are a lot of different opportunities regarding children, and then in the area of property, sometimes the parties can negotiate certain trade-offs regarding property issues. For instance, retirement. A person might have a strong feeling about their retirement, and if you come to court, often the court would say, if it was all accumulated during the marriage, you split it in half. In mediation, you might be able to trade off other assets and reach a settlement that the parties can live with.
So it really is a chance for the parties to fashion their own remedy, if you will, on what's going to happen to them.
It's a great opportunity for them for self-determination, rather than, again, rather than having the outcomes forced upon them by the court. they are in control of the outcomes in mediation.
How do they get to mediation? If, let's say, it's a divorce action.
We have a process in Jefferson County called a case management conference, and it is the initial meeting with the court. The parties, the lawyers, and the court meet. It's a rather informal conference. It doesn't last very long, usually about half an hour. It's a chance for the judge to understand what the issues are in the case, and then start to fashion orders which would direct the parties on how the case is going to proceed. And in our family court rules, it provides for the parties to go to mediation before we go to trial on the issues. And so at that point, the court would ask some questions of the parties and then try to get some idea of when in the process it would be appropriate to have the parties go to mediation. So part of the order that would come out of that case management conference would be some time frame on eventually scheduling the mediation.
Now, when we started this mandatory mediation, we just started out with the issue of children. Isn't that correct?
Correct. But it has evolved. I think that many people have seen the value of mediation, and there are a lot of pluses to mediation. And it has the rules have been changed to also allow property issues to be settled in mediation.
So you're going to order the parties, in this instance, a divorce case. We'll talk about mediation and other kind of cases here in a little bit. But in a divorce case, you're going to order the parties to mediation. You're going to appoint Mr. Gittleman or some other approved mediator. And David, what's going to happen when it comes to you?
I send out available dates to the lawyers if there are lawyers involved.
Let's stop right there. If there are lawyers involved. If there are lawyers involved, do the lawyers usually appear with the clients at mediation? Is that your experience?
More often than not. And there's several good reasons for it. It is common to have mediations without lawyers there. In some cases, it's a matter of economics for people to have a mediator and to have lawyers. I find that in most mediations that I conduct, the lawyers are genuine agents of reality, that they want to help their clients reach agreements. I think the clients can take bigger risks and reach more towards each other with their lawyers there than they can without, especially in property and maintenance matters. It makes as much sense. Someone going to buy an automobile is willing to pay a price closer to the value if they have an expert with them who is loyal only to them, and they can take a lot more risk in the bargain. And the same thing in a divorce case. Someone there to tell them, yeah, that's a reasonable thing. That's okay. Or it's not reasonable. When we come back from our break, I want to talk about cost and efficient use of time when it comes to mediation. Gentlemen, thank you. We'll be back in a few moments. Welcome back. Before we left for the break, we were talking about cost as it relates to mediation, and David, I know, and it won't come as a surprise to anyone, that we're going to pay our mediator. Isn't that correct? Yeah, actually, we're paid almost every time.
Okay. Judge, in terms of the time it takes to mediate versus perhaps the time it may take to work that same case through the court system, would you comment to the extent that you can on the cost savings, if any, that comes to the litigants?
Well, having a divorce resolved within a reasonable time is a high priority for family court. You have families that are in stress and need very important decisions regarding custody, visitation, property issues resolved in a timely manner. Last year, each of the family court judges had over 550 divorces on their docket, and total cases reached almost 2,000 cases per judge in family court. So you can see if we had to try every single case, it might take years in order to get your trial in front of the court. So we look for alternatives to the battle that takes place in a trial. And one of the alternatives is mediation. And mediation has provided a good opportunity for parties who can sit down and listen to each other, frame the issues that they disagree about, and then negotiate a resolution of those issues with the help of the mediator, who is not a decision maker, but a facilitator, and helps them listen and then discuss the issues and try to come up with proposals.
So as we talk in terms of cost, I guess what I hear you saying is, again, this issue of control. It is a mechanism for then the litigants to both control some of their costs of the litigation. That is, if I agree to work with David or some other mediator and get it resolved, I'm going to avoid all of that litigation cost that's going to get incurred down the line. And also here you're talking in terms of time. If I'm going to come to you and I want you to hear this custody case, and I want you to hear all the things I think important, you're going to give me that time, but it may not be in this month, whereas I may be able to get some time with a mediator within the month.
That's correct. But there are also some other costs too. I mean, if you go to trial, there are the emotional costs. If you go to trial, because our system is adversarial, you necessarily try to make yourself look as good as you can, and you necessarily try to make the other side look as bad as you can. And that often causes some very deep scars that are very hard for a family to recover from. Even after the court enters a decision and a decree and the parties are separated, and it leaves some very deep scars that sometimes they can never recover from.
David, can you kind of contrast with what you see in mediation in terms of what the judge has talked about with what he sees in trial?
Well, there are two costs, and the dollars are enough, really, in that when the judges order a case to mediation, they require the people to come for 2 hours. And that costs them $240, and probably the great majority of cases, there's certainly less than $500 of mediator's expense involved. A day of trial for a lawyer has to run $750 to $1,500 in the lawyer's expense. Rare is the lawyer who can try a case without twice as much time spent in preparation. Mm-hmm. So you're talking of thousands of dollars, and there's no way a custody case can be tried with less than thousands of dollars in attorney's fees. And then it's a judge's decision and it's not the parties. That's one cost. The other, this stress, and it's polarization, and it doesn't take a trial. Taking a deposition of a person is enough to polarize them. The demands and offers, the lawyerese, and I don't knock lawyers because they're a necessary advantage to a client in a lawsuit. But the lawyerese and that way of dealing, that polarization, is very costly to people.
And opposing experts also.
And that's in dollars again. But I'm just thinking here is a couple, a man and a wife, and they have a responsibility to children, and they in good faith want to carry out that responsibility. The kids are looking up to them. They're the gods in the kid's life, you know? And these gods, so to speak, are fighting, not getting along, being polarized by this process. There's a family to manage. Families are tough enough to manage when couples are getting along. It's really destructive for everyone involved. Mm-hmm. And I'm not saying the process isn't necessary of courts and trials and whatever, but if the people are able to work it out. Otherwise, it's much to their advantage.
Well,
And do you see, and excuse me, Judge, and do you see that when you're sitting in the mediation room? Have you had more than one experience where you maybe even see a little bit of healing, or at least a little bit of attempt to start to create some bridges that these folks can use over time?
It's remarkable. Now, many times people don't want bridges. They'll come in and say, "Hey, you help us reach an agreement. We want out of here. We don't talk to each other now. We don't want to talk to each other after we leave."
So you facilitating more of a settlement conference than a mediation.
Yeah. Now, I'll say to them, and I do in every case, we can work and get an agreement. You all can make the decisions you need to, and I have to tell you, I will feel we've done half the job. To reach an agreement, reach a settlement, make a decision, and not have made a connection. People are not free of each other when the kids turn 18. That's a game. People are going to have to deal with each other as long as they live. Their kids are going to graduate high school, they're going to go to college, they're going to graduate college, they're going to have kids of their own, and these people are going to want to come to the hospital when a grandchild is born without tension. So that mediation is an opportunity for them to begin down that path. Can't be done in one session, but
I interrupted you, Judge.
Well, and my experience is that if they are able to reach agreement on the issues, that they are more satisfied. And the reason that they are satisfied than going to trial, because it reduces all these costs by coming in and doing battle. If I have to make the decision, and I'll make the best possible decision for these people I possibly can, but I hardly ever please everybody in a case. Usually the parties walk away looking at my decision and they're happy about some of the aspects of it, they're not happy about others, and so they're coming back and saying, making motions to reconsider and making motions for a new trial. And so the litigation continues. Whereas if in a mediation session they are able to negotiate a settlement that they can live with, then for those people that's the best possible outcome that we could hope for.
Excellent, excellent. David, thank you for being with us today. We'll come back in a break in a moment, and Mary Lou Cambron will join us with the family courts. Thank you. Okay. Welcome back. Joining us for this last section is Mary Lou Cambron, who is with the Family Court Support Worker and the Project Manager for the Mediation Program. Mary Lou, thanks for joining us. Judge, I want to pick up before the break. We were talking about the timing of mediation, and hit for me just quickly, where in the process does mediation occur? You talked about the fact that it was ordered out of the case management conference. Does that mean it's necessarily going to take place within a month after that conference?
No, it's very important in order for mediation to be successful that the parties be prepared as if they were going to go to trial in terms of finding out information about the parties. They need to know what all the assets are. They need values of, for instance, a home or a business. They need to know what their goals are as far as the children are concerned. They need to know what they would like to have out of the process. And so often that takes a while for the attorneys and the parties to collect that information. Once that information is collected, and it is my firm belief that once all the information is present in a candid, forthright manner, and you put it on the table, that you can go to mediation and settle even the most complicated case.
All right. So we're not asking people to go mediate unprepared.
No, in fact, I think that if you asked any mediator what would be the top priority on their wish list, it would be that the parties come fully prepared with all the information available and a knowledge of each other's assets, of each other's goals in mind, and ready to sit down and have a good negotiation.
Excellent. Mary Lou, talk to us a little bit about the qualifications of a mediator, at least for the family court project?
Okay, for the family court project, our mediators are required to have a college degree with some background in behavioral sciences, or is a licensed attorney for the Commonwealth of Kentucky. We also require a 40-hour training program in regards to mediation. And then we also require some participation in mediation, that they observe so many sessions of mediation before they're allowed to mediate on their own.
Have you, I think you follow some of the statistics in this area, don't you? Why don't you give us some relevant statistics here? I guess we've got 100% of the cases going to mediation now, at least referred. Would that be correct?
Well, we probably don't have quite 100% of the cases going to mediation. Sometimes cases don't go to mediation for particular reasons. One of the statutes indicates that if you're a victim of domestic violence, then you're not required to attend mediation because mediation is a way to balance the table, so to speak, with the parties, and some victims of domestic violence wouldn't feel comfortable in a mediation setting.
I think that's an excellent point. I'm glad you brought that out. We don't put people, we don't separate them with domestic violence orders and then put them in the same room together and expect the field to be level.
Right. I think in some cases, though, I've talked with victims before who really want to go to mediation because they feel like that the tables would be more balanced for them. So sometimes it's up to the victim to be able to make that call.
And Judge, if I'm correct, I believe the statute allows for that. I think if there's domestic violence, am I correct that they can request a waiver of that provision and be permitted to go on to mediation?
I think it's one of our court rules that allow the parties to agree to go, and I think as long as the court addresses it and makes sure that the parties are comfortable with it, that sometimes some good results can come even from a family that's experienced domestic violence.
Mary Lou, do we have any statistics on how we're doing when the case actually is mediated?
Yes. Let me say first that the number of mediations is increasing every year.
Okay.
And out of the people that actually go to mediation, close to 72% get some type of an agreement. They may get a full agreement, or they may just get an agreement on several issues. But they are getting some type of an agreement.
And that's a good point that Mary Lou brings up, is that the judges are always hopeful that the parties will reach a full agreement. But we're very happy if they go to mediation and are able to settle some or most of the issues that are at hand. I often have parties who will come back to a case management conference after a mediation and inform me that all but maybe one issue, and it might be we can't decide what to do with the retirement. So the court will go ahead and hold a hearing to decide that issue. But all the other issues, there might be some very, very tough issues that they were able to work out that might have cost thousands of dollars to litigate. They were able to work out during the mediation, and one sticky little problem that they couldn't quite work through, and the court has a hearing and decides that issue. So again, it's a very valuable tool. Even if a full agreement isn't reached, a partial agreement is very valuable.
Excellent. Now, Mary Lou, I think we have what's in the courthouse, what some have called mediators, and you and I were speaking on this here before we started today. Tell us a little bit about that process. And I think it's in the paternity court, isn't it?
Well, it's in the paternity court. We also do some what I call pseudo-mediation. It's more negotiation with people in domestic violence cases and also in divorcing cases. Each court has a family court support worker who works directly with the court and will sometimes work directly with the clients to try to resolve issues of visitation and custody.
Now, is this a process where, you know, the worker's going to take, like Mr. Gittleman was saying, going to take all the time that it takes, or is this on a little more limited basis?
It's on a fairly limited basis. We unfortunately don't have 2 hours to devote to the process, so we try to assist people and clients to come up with the best solution that they can, given our time restraints.
But that process is a very valuable process to the court. And I believe it's a very valuable process to the parties. Often these parties are not in a financial position to pay for a mediator. They're not in, they have transportation problems often. They can't get away from their job often. And these cases often in court, when the people are already there before the judge, the court will ask one of the mediators, family support workers, to meet with the parties right then. And they'll spend half an hour sometimes trying to work through some sort of agreed parenting schedule, which often settles the problem between those two parties. And they don't have to make repeated trips down to the courthouse. They don't have to miss work. They don't have to put the children in daycare. They don't have to find transportation. I mean, it is very valuable to the parties in a lot of these cases.
And I would like to add too, Bill, that all the family court support workers have been through a mediation program, a 40-hour mediation program, training program. So a lot of the skills that they pick up in that mediation training program, they are able to use in that setting.
Judge, if we've got a mediated result in a case, are we more or less likely to see those folks back with problems on down the line?
I think, well, we are certainly less likely to see them back in court down the line for a couple of reasons. One is they have been active participants in a settlement agreement, and they have learned through the mediation process that they can sit across from each other and talk through these issues. And sometimes they need a mediator, and sometimes they'll come back to court with an issue, and the court will refer them back to mediation, and they're able to resolve it again.
Judge Garvey, thank you. Mayor Lou Cambron, thank you very much.
Thank you.
Thank you.